In the Brian Kohberger case, what happens if his defense attorneys successfully argue that the DNA was planted on the knife sheath?
With a lot of updates in the Kohberger case, is it possible that the defense is coming up with a new strategy? I'm Lainey Law.
And I'm attorney Andrew Myers.
And ever since those texts and those phone calls came out, it's been taking a hard turn in the Kohberger case.
Yeah, the texts and the 911 calls were really something that our viewers, and I think everybody, really scratched their head on and wondered, are these really valid? Are these really, were these correct transcripts? They're almost too good or too bad, depending on how you look at it, to believe. And people were saying, are those real? But the other two developments that have come out kind of simultaneously, but were buried beneath all those revelations, were the prosecution is now saying we're kind of concerned that the defense is fiddling around with the experts and saying that, you know what, we're going to tell the jury that the DNA on the knife sheath was planted. And here is the prosecution's motion where this was kind of buried. This is the state's response to the defendant's motion in limine number 11 regarding excluding the IgG evidence. So you know how they've been fighting over this investigatory genetic genealogy evidence for 2 years now, really. It's been, way over 2 years since the crime. And they've been battling over that. So they come in and they're talking about, the IgG and whether it's relevant or not. And, they've been going back and forth, and they recounted judge's order that, we're not going to disclose it. Well, okay, let me take a look at it in my chambers and I'll decide. And okay, now that I know it all, I might not understand it. I'm going to allow the defense to see only some of it. All of that was kind of a sideshow, because here is, again, the state's motion, and hidden way down, I keep scrolling on page 12. Here, the IgG information is even less material, if that is possible, than it would otherwise have been, because the defense has not disclosed any experts or evidence to challenge the confirmatory STR comparison. Wait, what? The defense isn't even going to have an expert with regard to the fact that the sheath had a little teeny tiny bit of touch DNA on it that could be traced to Brian? What? That doesn't make any sense. The defense has disclosed an expert regarding DNA evidence interpretation and the likelihood ratio to challenge one of the state's conclusions concerning DNA. Defendant's supplemental response to the request for discovery regarding expert witnesses. And then they give the exhibit number. But the defense has not disclosed any experts to challenge the confirmatory STR comparison showing the DNA on the knife sheath matched defendant's DNA. What? Wait, how can that be? The defense is not going to challenge the comparison showing the DNA on the knife sheath? Because, there's people out there that say his DNA was on the knife sheath. That's it. And there's people out there that have mentioned in our comments and elsewhere, his DNA was in the crime scene. That's it. Give me my knitting or a paperback. That's what I'm doing while all this evidence goes in. So, on the contrary, the defense has disclosed that its forensic biology and DNA expert will testify that, quote, there is good support that Mr. Kohberger's DNA was found on item 1.1, a swab from the knife sheath, unquote. Instead of challenging the conclusion that the DNA on the knife sheath belonged to defendant, the defense's expert disclosures reveal that the defense plans to argue the DNA on the knife sheath does not prove defendant was ever at the crime scene, and that the knife sheath itself could have been planted by the real perpetrator. Wait, what? So that is actually the defense that the prosecution goes on to say, if you look at the whole motion, that, that's what they're going to do, and we don't think that's right, and we're going to oppose that. So I found that pretty interesting, as did the local newspaper in Idaho. The Idaho Statesman interpreted it all and said, prosecutors, Kohberger defense to argue in Idaho murder trial, DNA evidence was planted. They talk about how attorneys for Brian Kohberger, who is charged with M in the deaths of 4 University of Idaho students, are set to acknowledge there's good support that their client's DNA was discovered on a key piece of evidence. Police said they were found at the crime scene, but are expected to argue at trial that it might have been planted. I don't know. That seems like a kind of risky strategy. If you talk to 5 different attorneys, they're going to come up with 5 different strategies on how to try a case, but that seems a little bit risky to me. I don't know.
But so far, I guess my question is this hearsay? Like, so far, like, do we know that the defense would actually do this? Because I agree with you that it would be like a risky strategy instead of just trying to prove anything else, to say that it wasn't intentionally left there. Because also it was such a small amount of DNA, right?
Yeah, well, the interesting thing is that they recently bounced Jay Logston off the primary defense team, and they added in attorney Becca Barlow, who is a California attorney, but she is an expert, a published, recognized expert in DNA. So let's not jump so quickly, but Kohberger's defense will attempt to establish that the DNA match to the only suspect in the case doesn't itself confirm that he ever visited the Moscow house where the 4 students were found stabbed to death. Prosecutors wrote in a public court filing this week, which we just read part of. 2 experts, one in DNA and another in forensic biology, will testify on behalf of the defense that they believe it is, in fact, Kohberger's DNA, the prosecution said. The lack in sealed defense filings of any expert witness who will assert the state is wrong, that Kohberger's DNA was on a knife sheath located next to one of the 4 victims, indicates that they accept the scientific finding, prosecutors said. Kohberger's defense team also hasn't provided any evidence to challenge the direct DNA match between a swab of his cheek and that from the knife sheath, the prosecution wrote. Instead of challenging the conclusion that the DNA on the knife sheath belonged to the defendant, the defense's expert disclosures reveal that the defense plans to argue the DNA on the knife sheath does not prove that Kohberger was ever at the crime scene. And the knife sheath itself could have been planted by the real perpetrator, read the filing signed by Latah County Prosecutor Bill Thompson and Special Assistant Attorney General Jeff Nye, who's also assigned to the case. So there they are at the table back in Moscow, Idaho. At a hearing on January, Ian Taylor, Kohberger's lead attorney, alluded to the DNA on the knife sheath as the most significant issue to be resolved at trial. That's the ultimate question that will be before a jury, she told the court. What does a knife sheath at a scene mean? And of course, I hate to break it down like this, but the quote unquote guilters, they're always saying, yeah, how are you going to explain the DNA on the knife? So, she's right. That is a big issue where they don't have anything actually of him going in with all the cameras that kids have these days, with all the, the series and the refrigerators with cameras, and my new washer and dryer are smart and have, hookups to the internet. With all of that, they don't have anything on Kohberger actually going in there, being in there, doing anything in there. They have nothing. They got nothing.
Even my thermostat in my house, when you walk past it, can sense that there's like a person there. So if the sheath is everything, then I don't know, depending on how they handle this, it might be pretty hard for the defense to prove, or for the prosecution to prove that he did it, if it's just the touch DNA and that it's planted.
Well, yeah, you know what? I went to a sandwich shop yesterday and had lunch, and I went to the counter and gave him my credit card, and then I went and I sat down and ate my sandwich, chatted with somebody, and then left. So my touch DNA is all over the place. I mean, if you know anything about DNA, apparently, your skin cells come off all the time. You touch the counter, you touch the little credit card reader, so my DNA is all over the place. God forbid something horrible happened there. And now my DNA is in there. So that's the type of an argument. And you've got to have a good faith basis in court for any argument. So the question is, will, Judge Hippler allow him to go down that road? Apparently, they're kind of shifting the focus away from that and saying, so what? It was planted. Somebody took Andy's DNA and planted it in the sub shop, which, this is a serious case. And that was a stupid example. But still, there's that. So Kohberger, we know, is a former graduate student of criminal justice and criminology at Washington State University in Pullman. We know all this. Washington, just on the other side of the Idaho state line from Moscow. After a 7-week investigation, he was arrested at his parents' home in Pennsylvania and brought to Idaho. And, of course, the victims were U of I students Kaylee Goncalves, Madison Mogen of Coeur d'Alene, Xana Kernodle of Post Falls, and Ethan Chapin, who was a triplet of Mount Vernon, Washington. The 3 women lived in the Moscow home with 2 other young women who went physically unharmed in the early morning attack. Chapin was Kernodle's boyfriend and stayed overnight. But how does this affect, and how effective will this argument be? Well, prosecutors have moved in a so-called motion in limine to have Ada County Judge Steven Hippler restrict the defense's ability to point to alternate perpetrators without meeting certain evidence requirements. Any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting the persons other than the defendant to the homicides would do nothing more than mislead and confuse the jury, Thompson wrote in a filing last month. So what does a big-time Idaho criminal defense attorney think about all this? Well, before we go to that, let's take a look at the actual motion. Here is the state's motion in limine regarding the alternative perpetrator evidence. So, in other words, if Kohberger's attorneys are going to say, he didn't do it, someone else did it, and we're not going to go down the tunnels, we're not going to go down the frat boys, we're not going to go down the Banfield tunnels, although they're still there and they're hanging out there. But for all of you Banfield and Linda Lane and frat boy theorists, what the prosecution is saying here is, nuh-uh, we don't want any of that evidence going in. Comes now the state of Idaho, by and through the Latah County prosecuting attorney, and respectfully moves the court in limine for an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to Idaho's rules of evidence. 401, 402, or 403.
Is that a thing that happens? They're just saying you can't use that argument? I don't understand how they're able to do that. Why wouldn't they just say that in the Karen Reed case too?
Well, the 2 different states, 2 different sets of circumstances, and this issue is before the judge. As a matter of fact, one of those 41 motions we were talking about does address this issue. And you're right, that'll be really interesting to see how the 2 different courts deal with that issue. And that's a great question we don't have the answer to right now.
I feel like they're just making up is that we don't want them to use this defense. It's just like, well, if you're not able to use a certain defense, what if that defense was going to be like the true defense? Like,
exactly. In this case, in Kohberger, if the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable, then it is within the trial court's discretion to find the evidence inadmissible. Mere inferences that another person could, in italics, could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of the rule. One thing that you've got to have before you make an argument in court is there a good faith basis? And the judge could certainly ask them, is there a good faith basis for this? In this case, in the Kohberger case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of those tips were substantiated. How much did they really look into them? Oh, I went off script. The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting the person other than the defendant to the homicides would do nothing more than mislead and confuse the jury, and would also result in undue delay, waste of time, would be a needless presentation of cumulative evidence and unfairly prejudice the state. Now, that last sentence just parrots the words of the relevancy rule of evidence, and that's fairly standard, doesn't matter what state you're in. So state of Idaho respectfully submits that the defendant Kohberger should be precluded from offering or arguing alternative perpetrator evidence without first meeting the relevance and admissibility threshold. So this is a fairly standard motion in limine. Some of the motions in limine we've been talking about are motions to have the judge allow evidence in, but this is a fairly standard type of motion in limine. They're saying, Your Honor, here's the argument or evidence that we anticipate. Here are the rules. We want you to take those arguments or evidence, measure them against the rule, apply the rule to the facts, and come up with the conclusion that favors us. That's a standard motion in limine. And this is signed only, interestingly, Ashley really is a hush today. William Thompson, prosecuting attorney. Jeffrey and I didn't sign this, and neither did Ms. Jennings. So back to how is all of this going to really affect the defense? Edwina L. Cox, a Boise-based criminal defense attorney, who, by the way, was Laurie Vallow's attorney, who just recently bowed out of the case. She filed a motion to get the heck out of that case. But anyhow, she's a very experienced criminal defense attorney in Idaho. She's argued capital cases. She told the Idaho Statesman, from where this article came, and we credited them at the top, that it would take considerable evidence from Kohberger's defense team to explain away the knife sheath DNA to the jury. Boy, that's an understatement, don't you think?
Yeah, but I mean, the whole like knife sheath, like all their other perpetrators and all that stuff, I feel like that's what reasonable doubt is all about. Like how she's saying that it would take considerable evidence from Kohberger's defense team to explain away the knife sheath. It's like ironic that the state is like trying to hide the knife sheath was planted and that there were other perpetrators theory, because that's what I feel like that's what court is all about, is exposing these different things. It's just like making the person think, well, can that really happen?
Yeah. So Attorney Alcox, who again did represent Laurie Vallow until very recently, says if it's just it wasn't him, his DNA is there, but he's not the one who put it there. She says that's pretty flimsy. Then how did it get there? How did his DNA get on the knife sheath where these kids are dead? Interesting point. But if they have real tangible evidence to support, and this goes back to what I was saying, you got to have some good faith basis to make an argument in court, or the other side can object, and to the judge's discretion, he can shut you down. If they have real tangible evidence to support an alternate perpetrator theory, other than just saying it's someone else, then that could be significant, or it could be really insignificant and not believable. It just depends on the content of what that is. Investigators found 2 sources of unknown male blood DNA at the crime scene, which the defense has already questioned in court. A blood spot was discovered on a handrail inside between the first and second floors of the 3-story Moscow home, while the other was found on a glove located outside of it, according to testimony from the lead police detective at a closed hearing in January. These DNA samples were not uploaded to try to identify them through the National DNA Database, known as CODIS, because they were not eligible based on FBI criteria, Thompson said at an August 2023 court hearing. The knife sheath DNA was, however, but did not come back with a match. And so now we get all down into the IgG issue that's been percolating, for 2 years now. It's been going. So it's just, as we get closer to the trial in the Kohberger case coming up, the jury selection is late July. The trial is set to start in early August. We're going to see more of this. We're going to see, these issues that have been out there, for 2+ years. We're going to see them percolating to the top in a motion to limine to the judge to decide, what he thinks is going to happen. So we've had a lot of thoughts, speculation, theories. I know it's this or I know it's that, but now it's coming to a head. It's really going to be coming to a head, and the theories and the evidence are all going to be hashed out. And that's what our viewers say. Here's what our viewers are saying.
All right. So we have Joe Vigil 2017. Excellent questions. Very organized and calm. And the utterance explanation was great. Thank you.
Oh, thank you. Not everybody is as kind as that, but you were. Thank you. Okay. Void says, on the 911 call, they are trying to give the impression they didn't see what happened to them, as if they didn't go to look. And why does the person immediately try to give a background story by telling what happened at 4 a.m.? Guilty people always do that on the 911 call. Well, I don't know. Is that what guilty people do? I don't know.
I don't
and
know.
Then the other one, Winnie 40SW, says, even preschoolers have successfully called 911 after recognizing what is needed. And that's true. And we've mentioned that, and commenters have mentioned that, and it's just the way it is.
David Wieskisher, 6911. The more we learn, the less we really know. This is why we need to wait for the trial. And I think a lot of people feel that way. I mean, because we can do all this speculation and all this talking right now, but at the end of the day, until that jury hopefully comes back with the verdict, we don't really know what's going to happen.
No, and little dribs and drabs have come out in recent weeks, like the thing that we had just mentioned about the blood inside the premises, the spot of blood, blood on the banister, blood on the glove outside. So little bits. And the 911 call and the text, little bits of it are coming out now. And so I predict that in the coming months, more will come out. So Donna Lembo, number 2, says, I really enjoyed the part of the video where both of you took different speaking roles in the 911 call. It made it seem more real. Mainstream media has been the most biased, often covering only a small portion of the story, which can lead viewers to get only half the picture or even inaccurate facts. So that's true. That's true. This case has kind of percolated back up to the networks recently. I've noticed with all the recent filings and the 2 motions that we just went over, I've noticed that, it's hit the evening news and the morning news shows, which I watch. I flip back and forth and watch a bunch of them, but they do like a 90-second piece. And so, they really can't dig into it.
And then for our last comment, that's from Lizzie Ann 904. I'm not usually a conspiracy theorist, but I'm beginning to think that the texts were staged. And that was actually a recurring theme that I saw in a lot of the comments. A lot of people were thinking like, oh, like she already knows the answer. Why is she sending that? Or commenting on like the time between the calls and saying that people aren't answering and stuff like that. So we're not saying one way or another, but this is a recurring topic that did come up in the comments.
Yeah, if you really thought about it, the 911 call didn't make a lot of sense. Several people pointed out, and it might just be because it was edited and we don't have it all, but the dispatcher pointed out that one of the victims was 20. Well, the age hadn't been mentioned at that point. And again, my answer to that, and I don't know, so my guess is as good as yours, is that they were edited. They cherry-picked bits and pieces, just like the probable cause affidavit was cherry-picked. And Dylan Mortensen apparently was interviewed 3 times in the days after November 13th of 2022, and they just kind of cherry picked and twisted around a little bit her statement, and that was Ann Taylor's unsuccessful argument to get a Franks hearing, because her argument, and I buy it, court didn't, I'm not a judge. Her argument was that they took little bits and pieces of what she said in those 3 statements and just kind of twisted them a little bit and put the bushy eyebrows thing in. And so, I don't know. It didn't seem to me that the 911 call or the texts made a lot of sense. And I know the people that are watching are the parents of the 4 Idaho victims, Kaylee Goncalves, Madison Mogen, Ethan Chapin, and Xana Kernodle. And we do have to mention them, every time, because, that's what it's all about. So I don't know. Do you have any closing thoughts for us, Laney Law?
I mean, always, as you know, we appreciate you guys sticking through the end with us. I know these topics are grim, and it seems like every day things just get more and more complicated, and people start to question in the judicial system and things like that. And we just, we're very lucky to have people like Andrew to be here and explain it for us. So I'm glad that you guys watched until the end, and we appreciate you guys.
Well, thank you. Here's my closing thought. And the attorney that was interviewed by the newspaper in Idaho says, is the jury really going to buy that the DNA on the knife sheath was planted? So the room is really split on this whole Kohberger, you're a guilt or a non-guilt or whatever. I've said a million times that I truly respect the constitutional requirement that we presume that a person is not guilty until found otherwise by a jury. But my question for our dear viewers is, if you're sitting on the jury in this case and there's DNA of the accused defendant on a knife sheath next to or under the body of one of the victims, are you buying the defense attorney's argument? It was planted. Are you buying that? Yes or no? Are you buying that the DNA on the knife sheath was planted? So that's my closing thought.
Yeah, I mean, ultimately, I think a lot of the people this whole time that have been saying that he's guilty is guilty. The DNA was one of their biggest things. So now to see that there's other DNA is going to pop some questions up for some people. But we appreciate you guys watching to the end. Thank you so much. Be sure to subscribe to our channel, like this video, and comment down below what you have to say.
Have a good one.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.